2023. We are calling to order the City of Oregon City Commission work session, and we will have the roll call. However, I will note that Commissioner Mike Mitchell is excused.
Commissioner Marl.
Here.
Commissioner O'Donnell.
Here.
Commissioner Smith. Here. And Mayor
Here. Tonight we have two topic items, and the first one is future agenda items. It's the City Commission's adopted goals and available staff resources shall be considered when recommending future agenda items. The Commission may add an item to a future agenda with the consensus of the Commission. I will turn it over to City Manager Tony Kong.
Thank you, Mayor, Evening Commissioner. So on next Wednesday, we do not have urban renewal at 6, so we've put in the Clackamas Park Master Plan discussion as directed by the Commission to bring that back for a discussion topic. And then we get into November, so our next work session, roughly a month from now, we'll start with a joint work session with the City of West Lynn, followed by a destination marketing organization discussion, a quick update from Willamette Falls, and then code enforcement code changes. So I realize that's a lot. We may pull one of those, probably the code enforcement, once we have a chance to look at how long those presentations.
What's the Willamette Falls? Is this the trust? Is this which?
The Willamette Falls Shared Youth Path.
Okay, sure. Yeah, because remember, there's so many things.
So we'll see how much information is associated with that since the last update you had about a month ago on that. So that would get us through November.
And then the proposed suggested items to have discussions with West Lynn are, of course, our favorite, I-205 tolling,
Homelessness
and the housing,
information coming out of the governor's
office.
Yes. Those are the three items that we were going to put together.
And anything that West Lynn has ahead of the game, like we were going to be sending them some of our stuff, would be very helpful so we can read. We'll also be welcoming their new city councilor. Can't remember Carol's last name, but you mentioned it earlier, so. Breik. She will be joining us at that time, and we will, so I think they're actually I think they're full. I think they have everybody now. So that'll be good.
Okay.
All right. So our next agenda item is a City Commission employment training issues, and this was something that we had talked about several times, and so we're very fortunate to have one of the premier experts in the field, Diane Rubinoff, who's here to enlighten us and get us on the right path of things we need to know.
Thank you. So, yeah, I was here a few months ago doing training for, supervisory training for all the supervisors, and so...
Is your mic down so that you can get picked up?
Let's try that again.
Well, you just need to tilt it down, not closer, but yeah, there you go.
Okay. So I was here a few months ago doing supervisory training for all of the supervisors and managers, and we're covering a lot of the same issues here, but I've tailored this really to things that I think you folks, as elected public officials, need to be aware of. And some of these things I'm just going to go through very quickly, just to kind of raise awareness. I'll try to stop at the end of each section to see if you have questions, but I welcome your questions as we're going along. It's just gonna, if we have lots of questions, it will affect the timing. I think we have a 7 o'clock executive session, so, but we can be a little late for that, right? Okay. All right. Okay, so.
A quick question before you begin about how many managers and supervisors took part in that. I don't even know how many we are, but how many there are.
All of them is 40.
Which is how many? Is
43, 42, 43.
Wow, okay, good, excellent.
And we spent a good chunk of the morning. This is, a 1 hour and 15-minute presentation, but we spent three hours together. And they asked a lot of great questions. Okay, so I'm just going to give you a quick overview of what we're going to be talking about. We're going to start off with the basic, discrimination claims, and what are protected categories. There's a difference between protected status and protected activity. And we're going to specifically talk about the Fair Workplace Act, which is the harassment policy that you folks have had since January of 2020. Public employers had to have a very specific harassment policy by statute. So we'll go over the basics of that. We're going to talk about First Amendment protections for employees and whistleblower protections. They are similar, but we'll talk about what the differences are. Then we're going to talk about discipline. So there's progressive discipline, and there is just cause, which, as we'll discuss, is mostly for your represented employees, that they are just cause employees. And then due process and name clearing. So due process is, it's procedural and substantive. And the procedural part of it is a pre-disciplinary process that you need to go through for just cause employees. And name clearing hearings, we call them hearings, but they're really just meetings. That's something that you may have heard of, but they are a very specific type of animal that we will discuss. We're going to talk a little bit about public records. I'm sure you've all had some familiarity with public records, but there are some specific ones that apply to employees, and we'll talk about that, and confidentiality of employee issues. And then the last thing that's hidden a little bit, Public Employee Collective Bargaining Act. That's something important for you folks to know about, and I'm going to guess that's maybe the thing you have heard least about. So we're going to talk about that as well. Okay.
Will you also be talking about the fact that now elected officials are required reporters if we perceive any harassment or, it was a state law that was passed. And I just got my material for the Oregon Mayors Association, and it's right up there in the, did you know, from the League of Oregon Cities, did you know that you are now mandatory reporters as elected officials?
I haven't heard about that in those terms. Elected public officials are covered by the Workplace Fairness Act. Any manager or supervisory person who learns of a harassment complaint has obligations to perform, such as, I wasn't going to go into that much detail about that, but providing a copy of the policy and making sure that the complaint gets routed to human resources primarily. So that's been part of the law from the beginning. But the statute speaks in terms of, managers, supervisors, and so now you're being included in that group that has obligations. Okay, so discrimination laws, the protected categories basically fall into two different categories. Protected status and protected activity. So let's look at examples of protected status. You're going to be familiar with most, if not all of these. We all know about race, and sex means gender, and you can have sex discrimination that is not about sexual activity. If you are treating one gender differently, that is sex discrimination. National origin is about not your race necessarily, but where you were born. So, for example, if someone's being discriminated against because of their accent, that would be about where they're from and not necessarily about their race. Religion, age. Oregon's a little different because it isn't just people who are 40 and older. Like under the federal law, people who are, you can be discriminated against, and it's legally protected if it's because you're younger. So, for example, if you don't get a promotion because you don't have enough gray hair, that could be an example of age discrimination in Oregon. Sexual orientation is about who you choose to have sexual activity with. versus gender identity, and that is what gender you identify with. Disability, I'm sure you have some familiarity with the Americans with Disabilities Act. Oregon has their own version of that. You can be discriminated against because you have a perceived disability when you don't actually have one. So, for example, alcohol addiction is a protected disability. If you perceive that an employee who gets a DUI has an alcohol problem, that is a perceived disability, or also called a regarded as claim. You're regarding them as disabled when they're really not, and that's actually protected. A past history of a disability, even though the person doesn't currently have it, so maybe somebody had cancer, maybe they had a workers' comp injury, you discriminate against them based on that, even though they're not currently disabled, that's protected. And then we'll talk just a little bit about accommodating disabilities. That's the failure to accommodate is also discrimination. And citizenship, you have a right as an employer to know that someone is authorized to work, but you can't discriminate against them because they're not a citizen. So those are just examples. There are other protected, marital status is a protected status, veterans, those are just, some of the more common ones that we see. Protected activities, so this is really, going to be your retaliation claims. If you are discriminating against someone because they've engaged in protected activity, that's usually retaliation. And here's a list of things that we see commonly as far as discrimination for protected activities. Just reporting you have a work injury, you don't even have to file a workers' comp claim. That's protected activity. Taking military leave, complaining about safety hazards, like filing an OSHA complaint, whistleblowing, we're going to talk more about, taking protected medical leave, opposing discrimination, harassment. You don't have to be the one who's harassed. If you're doing that on behalf of somebody else, that's engaging in protected activity. Complaining about your wages, that doesn't mean I'm not getting paid enough, but we have the Oregon Equal Pay Act that is very active now, and I'm sure Patrick's worrying about that on a constant basis, making sure that people who are doing comparable work are being paid equally, and Oregon is a trailblazer on that. Most of the states that is focused on gender, when gender is being paid differently for comparable work. Under Oregon's law, it's any kind of protected status, age, religion, and things that the employer doesn't even necessarily know about. You don't necessarily know what everyone's religion is, but if you pay two people differently who are and doing comparable work, and they happen to be of a different religion, that gives them standing under the statute to sue. So it's precarious little statute. And then engaging in union activities, and we're going to talk more about that. Sorry, oops, skip the screen. So types of discrimination, intentional discrimination is going to be things like harassment, retaliation. You know you are discriminating against someone when you do that. Disparate treatment is sort of the middle category here. You don't have to intend to discriminate as long as you are treating two people differently on the face of it. And so, one example that I can give would be when I first started as an attorney 30 years ago, in my law firm, women were not allowed to wear pants, or it was discouraged. It wasn't prohibited, but it was discouraged. And so that's treating men and women differently on the face of it, and there wasn't an intent back then to discriminate on that basis, to be discriminatory, but in fact it was. And then disparate impact, that's a little more subtle, where you, on the surface of it, you're treating everybody the same, but it has a disproportionate impact on a protected group. So, for example, if you have a laborer position and you require a college degree or maybe even a high school diploma when that is not required for the job duties, that is going to tend to have a disproportionate impact on some minority populations. Physical requirements that disproportionately impact female applicants or candidates if it isn't required for the job. So that's called disparate impact. And there are some very creative theories that come out in the courts on these types of things. Okay, the Workplace Fairness Act, what I wanted to focus on was, elected public officials as of January 2020 had to be covered by the harassment policy. This resulted from actually my investigation of Senator Jeff Cruz in the Senate after he was accused of sex harassment by 2 female senators. And prior to that, there wasn't anything under Oregon law that made it actionable if an elected official engaged in that conduct, or similarly that protected, in this case, 2 female senators from that kind of behavior. So this law was enacted. It is not limited to sexual harassment. It covers most of the types of discrimination against a covered individual. The law prohibits an employer requiring an applicant for employment or a current employee from entering into a non-disclosure agreement that they will not talk about their harassment. You can't have a non-disparagement provision anymore, and you can't have a no rehire agreement. And those are things that we typically would include in the past in a separation agreement with an employee, and we are not able to do that anymore. And then also the statute of limitations was changed from 1 year to bring a claim to 5 years. So for these discrimination claims now, an employee can go back 5 years.
Would this have applied to Representative Ruiz, who had some issues?
If it was after, if the conduct was after January, actually October, so it was a little bit earlier. The policy part came into effect a little bit later. So October of 2019 was when the statute of limitations changed, and when elected public officials became covered by the law.
It was Hernandez, not Ruiz.
Oh, sorry, okay. Yeah, and then there was, of course, Senator Packwood, but that was way
back.
Way back.
Yeah. All right, so First Amendment free speech. This is, again, this is one of the categories that I think is really important for you to be aware of. Everybody is aware of First Amendment, but not necessarily how closely things get sliced and diced under this law. So First Amendment, this just applies to public sector employers. And so when does it apply, the free speech clause? So first of all, the employee has to be speaking as a citizen. If you're a public employee, you don't lose your right to speak as a citizen. It needs to be about a matter of public concern, and that is very broad. So I've said here, any matter of political, social, other concern to the community can be a matter of public concern. So, we said the employee has to be speaking as a citizen. There is an exception if the speech is part of the employee's actual job duties, then it's not going to be protected by First Amendment. So, I mentioned this is sliced fairly thinly. So there was a case involving the city of Scappoose a few years back. It was actually the former city manager who was sued by the police chief, and that was because the police chief had spoken out about financial mismanagement. He complained about what was happening with his budget as police chief, and also, financial, how money was being spent in other departments. And so when this went to court, the court applied the law was it a matter of public concern? Was he speaking as a citizen? And the outcome was that when the police chief was complaining about issues related to his own department's budget, that was not protected speech. But when he was complaining about matters related to other budgets within the city, that was protected, and that resulted in a $4 million judgment.
Against who?
Just the former city manager, whose name was
Oh, no, that's
Hinton.
yeah. So what you're saying is that when that particular employee was talking about other budgets, so it was the city manager that disparaged them or
Retaliated.
Oh, retaliated.
Retaliated,
Okay. I
started
missed
a
that.
series of investigations. I'm
Okay.
sorry, I missed that part. So, started a series of investigations against the police chief, and ultimately, another city manager, Don Otterman, that's a familiar name, ended up terminating the police chief based on those investigations. The former police chief did not sue the city and did not sue the city manager who actually terminated him, but sued the former city manager who had retaliated. And Bill wanted to say something.
And I would just say that $4 million was against, might have been against the city manager, but it's the city.
It's city pays, yeah. It's actually.
Hope they had good insurance.
Actually, yeah, probably CIS, City County Insurance.
So D, is that employees only, or is that also elected officials? Does this apply to elected officials also?
Yes,
Okay.
and I'm going to show you, I'm going to talk about a First Amendment case regarding, I'm sorry, so yes, it would, retaliation cases can be brought on an individual basis against, and individual discrimination cases can. I don't know about free speech and whether that can directly be brought against an elected official. Definitely any kind of discrimination, harassment claim, it's called aider and abetter liability. And so an elected official that is the person behind the discrimination can be sued individually as an aider and abetter. I'm not sure about free speech and whether typically that would be brought against the employer, not against the elected official or the city manager. I am going to talk about, when we get to the Public Employee Collective Bargaining Act, a specific case that was brought against an elected official. Okay, so question, does that mean that employees can say anything that they want to as long as it's a matter of public concern and they are speaking as a citizen? No, there is a balancing test. And so the court, or it ends up being a jury in most cases, is going to balance the employer's interest versus the employee's interest. I will go through this next part quickly just to give you an example. This is a case from one of your close neighbors, and this was a case that I took to arbitration, and it involved a police officer, happened back in 2016, who was making Facebook posts about Black Lives Matter, anti-Black Lives Matter. And so some of the posts that he put on his personal Facebook page was about a day of target practice, which citizens took this meaning it was target practice against Black Lives Matter protesters. He posted this thing about Portland State University students laying in the street, said, "Where's a pissed off redneck in a Kenworth when you need one?" A Kenworth is a big giant truck. And then another posting was, survived 3 tours in hell, only to get it from one of Obama's children. So this was considered to be political speech. He actually was protesting on behalf of police officers who were getting killed. There was a big shooting in Texas where a lot of police officers were killed. And that's what he was protesting with this on his Facebook page. So, actually, so we can't see the... It went to arbitration after the police officer employment was terminated. The arbitrator found that he was speaking
So how
as...
did the city find out because of these things that were leaked on KGW?
It was leaked on KGW.
Okay.
Yes, you paid attention, yes. Somebody who was a Facebook friend, it was a Facebook page that was open to the public. The employee didn't realize that, but somebody who saw that ratted him out, and so he ultimately was terminated, and the arbitrator found that he was speaking as a citizen. It was a matter of public concern, but in that balancing test, the arbitrator found that the officer's First Amendment rights were outweighed by the employer's interest for these three reasons. The postings created a perception with the public of racial bias and advocating violence. We had lots of evidence from people who called in that citizens were taking this as racially motivated speech. It called into question his ability, because of this potential bias, to testify as a police officer, which was an essential function of his job. And it created safety problems within the city. There were death threats. There were concerns that other police officers would get targeted. We had, he was taken off work, but there were concerns about other police officers in the city. So, yeah, this was West Lynn, and this officer did not come back to work. He did, however, get a bunch of back pay. The arbitrator decided to kind of split the baby, which happens frequently in arbitration. He got back pay, but was not put back to work. I've got a note here that this could have a different outcome if it was religious expression. So the First Amendment covers religious expression, which can also be free speech, and we're seeing a lot of activity, especially at the U.S. Supreme Court level, regarding religious freedom cases. And the City of Bremerton case, which went to the U.S. Supreme Court, was about a football coach in the City of Bremerton. And after the games, he would gather up the football players on the field immediately after the game and do a prayer service with them. And a lot of people were upset, some students would be coerced. He was a high school football coach, that some of these students would be coerced into participating in that when they didn't believe what was being prayed about. But the other problem was that a public employer cannot be seen as endorsing a religion. The Establishment Clause in the Constitution says that you have to have separation of church and state, right? So there was a concern that the football coach doing this on the football field right after the games gave the impression that the high school was sanctioning or condoning this activity. So the school district prevailed in the trial court. School district prevailed at the Ninth Circuit level, Court of Appeals. U.S. Supreme Court reversed it, and football coach got his job back after he was fired. So I think we'll be seeing more of that on the
weren't there a series of steps where they specifically asked this person to please not do that? I mean, you could do it, but don't do it on
They spent a lot of time trying to, keep from having to fire him, and he was just blatant about it and would not change the way he was doing it. So, yeah, you are up on your con law.
Well, the reason I was particularly interested in it is because I also had a concern when I was reading this, and then I know some people that live in that community, that there were students who felt like they were being ostracized if they didn't participate in it, and so they didn't know how to say, thank you, but no thank you, I'm going to the locker room, and they,
I can tell you the U.S. Supreme Court did a lot of cartwheels to get to this result. Doesn't make a lot of sense to me.
So they basically said that it was okay that he was doing that?
It was too great a restriction on his free speech, that he, it didn't really create the impression that the school district was sponsoring this. They just, they made the decision go where they wanted to go.
Yeah, it wasn't the public perception, I can tell you that.
Okay, whistleblower claims, again, similar to First Amendment, a little different. So there are two statutes at play for public employers. The first one, 659A.199, applies to all employers in Oregon. You cannot discipline or retaliate against an employee that, in good faith, reports information that they believe is a violation of any law. Okay, any law will do, but for that one, that applies to private and public employers, it has to be a violation of some law that they think has been violated, that they are reporting about. And in good faith means they don't have to be right, they just have to have a good faith belief about it. The one that applies to public employers, it goes even farther, it's even more broad, because it doesn't have to be a violation of law. It can be reporting something the employee thinks is mismanagement, needs to be serious mismanagement. You see the word gross waste of funds, so the courts have said it basically needs to rise to the gross mismanagement level as well. Has to basically be something very significant that undermines the agency's public mission, is what the courts have said. Abuse of authority or a danger to public health and safety. A harassment claim by a supervisor will be enough to be whistleblowing. Okay, so you can't retaliate, you can't take disciplinary action, but really any kind of adverse employment action, doesn't just have to be discipline, will be enough for a whistleblower claim. So just to kind of go over the differences between these two things, for your whistleblower claims, it doesn't have to be a matter of public concern. It can be something internal that just applies to that employer. So there isn't that hurdle that, that it has to be about a matter of public concern, and they don't have to be speaking as a citizen. It can be part of the official duties that they are reporting about, and that is protected under whistleblower. For your First Amendment claim, it doesn't have to be a violation of law or gross mismanagement. It just has to be that matter of public concern. So, the type of speech is going to vary a little bit, depending, and some types of speech are going to qualify under both. Okay, so just a brief word about when it is not enough just to treat employees equally. Disability accommodations, you have to make special accommodations for folks with disabilities, and the idea there is you're really just bringing them up to a level where they are equal. If their disability can be reasonably accommodated, then you are making them equal with other employees. Religious belief accommodations, those are pretty broad. If you have some questions about that, it can be time off from work, it can be having to give breaks for religious prayers. Under both the disability accommodations and the religious belief accommodations, the employer's defense is, that creates an undue hardship for our workplace. But who gets to decide? If you say, no, we can't accommodate that, and the employee brings a claim, it's a jury that's going to decide whether there was actually an undue hardship. So you're rolling the dice a little bit. And then veterans' preference in hiring, your veterans, when they apply for public employment, are going to get a little bump in the hiring process. At every stage of the hiring process, they get a little bump in the points. Your hiring process basically has to be boiled down to scoring with points on the equivalent of a 100-point scale. Your veterans are going to get at each stage an extra 5 points in that scale, and disabled veterans are going to get an extra 10 points. Okay, so one thing just to be aware of with disabilities is what I call the crossroad Gambini situations. They're called that because it's named after a lady named Ms. Gambini, and it's what happens when an employee engages in poor work performance or misconduct, and during the when they're being confronted with that performance issue or misconduct, they say, it's not my fault, it's because of my medical condition, okay? And we see that happen a lot. So does that mean that an employee gets a free pass on that performance issue or behavior problem? No. They're really, an employee might think that they're going to get a free pass, but at that point, HR is going to say, hold it, we're going to put the brakes on, and we're going to go down an accommodation path here. We're going to find out if your doctor agrees that your behavior or performance problem is being caused by your medical condition, your disability, and if so, what's the solution? You don't necessarily get to keep engaging in that performance problem. You don't get to keep engaging in that misconduct. They might need to have some time off from work. That's the accommodation. They get time off from work if that problem can be brought under control. Lots of times we see it's just a medication issue. They change their medication. They need time to adjust to new medication. So that's
what was the bottom line of the Gambini situation?
She had bipolar disorder, and she was engaging in temper tantrums in the workplace. And after she was terminated, that case actually got reversed at the Ninth Circuit level. The Ninth Circuit Federal Court of Appeals is very employee-friendly, and it turned on the fact that her supervisor had reason to know that she had that problem and did not do enough to see if there was a way to help her get that under control.
So would it have gone a different way had the supervisor or the employer not been aware of this or had no clue about what was going on?
Yes, so you have the case law requires a jury instruction that is very employee friendly, whereas the EEOC position is if you find out about it after you've already made the decision and anybody would be terminated for that, then you can go ahead and terminate. If you're not going to terminate, then you have to go into the ADA accommodation process and see. Yes. So if it's brought up, and very often we see, the union will bring it up at the very last moment in the pre-disciplinary meeting, and at that point you're talking to our office and CIS because these things can get complicated. But the bottom line is the employee does not get to keep engaging in misconduct or poor performance just because they have that disability.
I can see where in those sorts of cases, no matter what the disability is that it really puts the employer in a very bad situation because you could have an employee going along, everything's really, really great, and all of a sudden it's like something weird starts happening. The employer has no idea that something is going on. Maybe they don't even know that the employee maybe takes medication or they don't know anything. And it seems to me that it is really unfair to the employer to have to take a pass about something they have absolutely no knowledge about. I mean, again, as you stated, it's one thing if they were aware or reasonably could have been made aware, like, okay, Jane Doe, all of a sudden everything's great, and all of a sudden you just like, they flip out or something, and you go like, well, what's wrong? Is there something wrong? What's going on? I mean, there's a lot of inquiry, I presume, that can get asked. And sometimes people are forthcoming, and sometimes they are not.
Right, and it totally depends on when in the discipline process.
When you knew that you should have known. Okay.
Well, it all depends on when the employee raises it. If they've already been terminated and they never said anything, and they had an opportunity to say something.
Oh, by the way, I have X.
They're not. Then it's not going to work. So.
Yeah. Okay.
Okay, so just quickly, other protected absences, that you need to be aware of. Medical leave can be, Family Medical Leave Act, OFLA. Now we have Oregon paid leave, which is also another 12 weeks. But now that Oregon paid leave is starting, and it's going to catch up. It's going to catch up, and it should all start running concurrently. So it's not 12 weeks, 12 weeks, 12 weeks. Problem is that OFLA kicks in at 6 months of employment, and FMLA kicks in at 12 months. So you can kind of have the juggling situation if an employee needs it when they qualify for OFLA, but they're not FMLA yet. domestic violence leave, that requires some safety accommodations, as well as leave if the employee or their immediate family member is a victim of domestic violence, military leave, jury duty is protected, and some employers pay for it, some don't. But the employee has a right to take their jury duty leave. Volunteer firefighter leave, we don't see that so much. We don't see very much of the bone marrow or organ donor leave, and we don't really see very much of the crime victims leave. Okay, so Denise has been asking great questions. I'm assuming nobody's got questions yet on any of the stuff we talked about. This is a little complicated, but it's very important for you to know about. There are two different systems for private employers and public employers. Federal law applies for private sector employers if they have a union. That's the National Labor Relations Act. In Oregon, public employees are governed by the Public Employee Collective Bargaining Act, and that is managed by a state agency called the Oregon Public Employment Relations Board. And that is a 3-member board that makes decisions if the union claims that the employer has engaged in an unfair labor practice. So that's one avenue a union can go if there's an unfair labor practice. If the union says there's been a breach of the collective bargaining agreement, then that normally goes to a grievance arbitration, and an arbitrator decides that. So it depends on if it's a breach of the contract or some other unfair labor practice that the Employment Relations Board is going to handle. We're going to be talking about the unfair labor practices. So public employees have the right to form a labor organization, join, and participate in the activities. So a public employee, if they're not currently covered by a labor unit, a bargaining unit, and they want to start one, that is protected activity. And we had, again, your close neighbor, had a case with a police sergeant who got into some trouble because he was trying to start a sergeant's union, have the sergeants be allowed to be in a union. And he kind of went about it in not a great way because he was trying to recruit people into doing that, including some brand new police officers, by alleging that the police chief was engaging in criminal activity. So he kind of went a little too far, and people got upset about that, and it turned into a big issue because it was potentially legally protected activity, even though he wasn't currently in a bargaining unit.
But he was trying to do one.
He was trying to start one, yes, so that's legally protected activity. So another thing that you need to be aware of is that you have employees in the workplace who are union representatives. And those employees, when they are acting as a union representative, wearing their union hat, are allowed to get to engage in some conduct that would not be allowed if they were acting as an employee. And there's not a bright line there, so I'm not going to try to tell you this is protected, this isn't protected. It's just something that you need to be in touch with our office.
Could you give one example that you're aware of?
Well, it can be, raising your voice. If you are yelling at your manager, that's generally not okay. But you might be able to have that be permissible conduct if you are engaging in that kind of interaction with a supervisor when you're wearing your union hat. Okay?
At what point do you become a union representative? Are you formally recognized by a union as your representative, Or are
They might
you
be
trying to
steward.
form a union?
So there might be a union steward that represents
Right.
people in discipline meetings. It might be a union officer, the president of the union. The local the unions have employees who are elected to
Okay. So it's
positions
formal.
within the union. Yes,
Okay.
yeah. And
I just want to make sure you weren't self-appointed.
No, they have to
No.
be.
it's not just any
Yeah.
employee. Yeah.
In the one that I was in, they
Generally,
were elected. They were-
I'm not gonna make an absolute rule that if you're just somebody in the union, you don't have that protection, but generally it's somebody who's wearing the union hat.
Do they still call them shop stewards?
Shop stewards? Yeah, stewards,
Yeah.
yeah. Shop stewards is sort of from the private sector when you literally work in the shop.
Work in the shop,
right.
yeah.
More employee rights under PECPA. The employer has to bargain over changes in things that are called employment relations. So, anything that's employment relations can be raised during negotiations. Every 3 years, you enter into a new bargaining agreement, right? And so, the union can ask for those things, during negotiations. And, the employer needs to bargain. The employer doesn't necessarily have to agree, but the employer has to engage in good faith bargaining about that. And employment relations is very broad. So it's money, it's work hours, it's benefits, it's discipline procedures, it covers many things, safety issues, then if the employer wants to change a policy or a practice during that 3-year period when the agreement is in effect, same thing applies. Employer can't just make changes to those things. Employer has to give the union an opportunity to demand bargaining over that. Otherwise, even after you make the change, the union can say you shouldn't have done that, and then you have to go back and bargain.
So Dee, how would this also apply? So I've been in a situation where there was a represented employees group, but there also was a managerial union group. It was everybody but the executive director and that person's direct assistant. Everybody else who was a supervisor or a department head, they were in a union.
So under public employee...
And there was public employees.
The Public Employee Bargaining Act says that basically a managerial employee cannot be in the union. True supervisors can't be part of the union, and managers cannot be. Managers for the state of Oregon, sorry. The management one is only for state of Oregon employees. But if you're a true supervisor, you can't be in a union. Now, an exception was made for in the fire industry, the fire unit. So a battalion chief, for example, even though they're a supervisor, I don't know why that exception was made for them, but there is an exception for them. Where you will see somebody like a sergeant trying to form a union, it's because they're claiming we're not true supervisors. We don't really function as supervisors. But if they are true supervisors, and that's a test that's defined in the law, then they can't be in the union. Okay, and then there's a new law that says employers have to provide on-duty time for designated union representatives to engage in union activities. So we've seen a lot of negotiating over that. So now we're going to talk about like unfair labor practices against employers based on kind of a retaliation theory, discriminating or retaliating against somebody in relation to their union activities. And so there are two kinds of this. There are because of, you do something because an employee engaged in their union rights, exercised their union rights. And that can be like they brought a grievance and you feel like they didn't tell the truth in their grievance, right? And now you want to discipline them for that. So that would be because of union activities that they engaged in. The one that's really precarious for employers is the unintentional one because it's so broad. So you are treating them differently in the exercise of their union rights. And this is based on a finding. If a union brings an unfair labor practice because the employer interfered with the employees in the exercise of their union rights, it's based on a chilling effect on some fictional employee. They don't even have to prove that you had a chilling effect on the employee that you did it to. That's why it's so broad. If it could discourage union employees in general from exercising their rights, that can be an unfair labor practice. And here's where we're going to talk about a case that did involve an elected public official. And it was the city of Lebanon, and this happened in 2012. So a city council member wrote a letter to the newspaper urging the union employees to exercise what they thought was their right, encouraging the employees to go on the Department of Labor website to find instructions on how to decertify your union captors. Now, I want to point out, this is not surprising that the union got upset about this, and union employees got upset about this, and that this could be seen as a chilling effect. This can happen with something that's much more subtle. If it's something that can be seen as discouraging employees from exercising their rights. I'll tell you about, again, I'm relying on your neighbor city, and police chief who was found to have engaged in this chilling effect with an employee who was the union president. Employee went for a promotion to become a sergeant, and the police chief, the employee didn't do well in their panel interviews, and the police chief said, maybe you've got too much on your plate.
Oops.
That's all it took. It didn't say because you're the union president. Could have meant other things, but just that statement, maybe, you didn't get promotion because you've got too much on your plate. And that was enough for a finding that the person had been engaged in an unfair labor practice. It's an administrative law judge that holds a hearing and then makes recommendations, and it goes to the board, and the board found that was enough in that case to have a chilling effect, not just on that employee, but on union employees in general. So, but back to this, in this case, the Employment Relations Board found that this was a violation of the in the exercise prong. They said we don't have to find that it was a violation of the because prong, because it's enough that it was a violation of the in the exercise prong to encourage employees to go get decertified. And the Employment Relations Board also found that the union had their own claim here for interference with the union's relationship with the employees. Okay, I don't know if there are questions on that. It's a very broad area of the law.
Yeah, but it seems to me that the elected person who doesn't have a direct relationship with the employees, I mean, it's through that manager or supervisor or whatever, it's not directly to them. It's like, okay, that's a dumb person. I would even say that.
And, it's, in a case like that where somebody doesn't have monetary damages, the remedy is, you have to post that you were bad. You might have, if it's egregious, the employer might get a small fine. The remedies can sometimes be just, really a slap on the wrist. But it can be a big win for the union in upcoming negotiations. It can even if there isn't a monetary penalty that goes along with that, it can be it can really affect the employee relations with the union. Okay, and discipline, are we okay if we go, I mean, do we have a stopping point here? All right, we'll be done easily by 7:30, I promise. Okay, so we're going to talk about discipline now. And so progressive discipline is pretty much just what it sounds like. For minor violations, you need to go through a progression. The city's personnel policy follows progressive discipline. And we're going to talk more about that in our next session. So it says that employees will be assessed increasingly severe penalties each time an offense is repeated, or if the employee doesn't correct performance deficiencies. Progressive discipline doesn't have to be the same violation. It can be based on different types of misconduct where you progress up to the next level. The steps are identified in the policy are oral and written warnings. You start with those, and then you would eventually you'd move up to suspension, depending on how serious the conduct is. It says with or without pay. If you're under investigation, you'll be put on admin leave. That's going to be with pay. Suspension with pay is very rare, but sometimes the employer, can say you're suspended, and it's for decision-making leave. We're going to pay you to go home and think about what you did wrong, and tell us, why you're going to do better. You don't see that step very often with a union represented employee, but if it's performance deficiencies or conduct, and you really want the employee to show that they understand and they're promising to do better, you might do a suspension with pay and do that decision-making leave. Then there's demotion if the person truly has shown that they're not capable of doing the job, and then finally discharge. Under the progressive discipline policy, the city gets to decide how serious it is, and whether we're going to skip steps or we're going to go directly. It's serious enough we're going to go directly to a written warning if there hasn't been an oral warning, or what's serious enough we're going to go straight to a suspension, or serious enough that you're going to be terminated. So we're talking, this is the general policy for all employees. We're going to talk a minute about union represented employees and how you can't just go by the policy, which says city has discretion to start wherever they want. Okay? And then lastly, the overall record is going to be considered in deciding how serious the discipline is. Just want to quickly point out that for union represented employees, it's usually built into the contract that a written reprimand is going to become stale after a certain amount of time, and you won't be able to use it anymore for progressive discipline. Okay, so now let's talk about due process
I have a question, Dean.
How that affects discipline. Did somebody have a question?
Despite the fact that it's called an oral, whatever is record.
Oral warning?
Should there not be a written record made of an oral warning?
So a lot of employers will do an oral warning that's reduced to writing, and you actually have the employee sign it. And the unions are used to that. Sometimes that's built right into the union contract that you can have an oral warning reduced to writing. But an oral warning can also just be it is just oral to the employee, and then the supervisor documents that it happened, and you put it in a supervisory file, and then you wait until the employee's performance evaluation, and you incorporate it into that if the employee hasn't engaged in further conduct. So I find it kind of a strange animal to say it's an oral warning, but it's reduced to writing, and we're going to make you sign it, and it goes in your file, so.
I didn't think that was
that's
necessary. I thought documentation of it was necessary, though.
So you want to at least, if it's an oral warning, the supervisor wants to at least document that
Right.
it happened. It doesn't go in the personnel file if it's an oral warning. You just document that they were told and when they were told. Okay, so, we're going to talk about due process. First, we're going to talk about substantive due process, which is based on the due process language in the Fifth Amendment of the Constitution, which if you want to impress your friends at a cocktail party, it's actually the 14th Amendment that applies to the states. So the Fifth Amendment is federal, and the 14th Amendment makes everything under the Fifth Amendment apply to the states. So you've heard of, life, liberty, and the pursuit of happiness. Your employees are not constitutionally guaranteed the pursuit of happiness as an employee, so that's good news, right? But they are guaranteed liberty and property, their property interests. And so first we're going to talk about substantive due process, which is a property interest that employees get. Come on.
Okay, that'd be crazy.
Okay, this is not advancing. There we go. Ooh. Okay. A property interest that employees get in their employment when they are a just cause employee. So every collective bargaining agreement says employees can't be disciplined without just cause. That gives them a property right that is legally protected under the Constitution, due process. And so that property right can't be taken away from them without just cause for the discipline. So it can come up in a collective bargaining agreement. It can also come up in an employment contract. If an employee has a contract that says there has to be just cause for discipline or termination usually. It can arise even accidentally under an employer's policies. It might be a law. So for instance, firefighters have civil service protection that says they have to, there has to be just cause for them. If they're not in a collective bargaining agreement, they still have just cause rights under a statute. Okay, so just make sure we're all on the same page. It's a substantive due process right that employees have if they are just cause employees. Okay, so just cause for union employees is a traditional test that arbitrators will apply in a grievance arbitration. And basically, it's a 7-part test. It says there has to be a thorough investigation. It has to be a neutral investigator. The investigator can't be biased. And the decision maker can't be biased, okay? If for example, the investigator is, maybe it's Patrick, and he's a witness in the case, that's going to be a problem. There's potential bias there. And this is why we very often do outside investigators. You can't have an investigator if the accused person is somebody that the investigator reports to, right? Because now they're not going to want to find against the person they report to. So there are all kinds of ways that a bias can arise where you need to have an outside investigator. And then same thing with the decision maker. You don't want a decision maker who's got some basis for bias. Maybe the employee has made a complaint against them in the past. So now there's an argument that maybe that person has a bias against them. You have to prove that the employee did what they're accused of. That's a big one, and that's where very frequently where grievance arbitrations fail. The employer just doesn't prove that the employee did what they allegedly did to their arbitrator's satisfaction. It can't be unfair discipline because other employees have done the same thing and not been punished for it. The employee has to have notice of the rule. It isn't fair to discipline an employee if they didn't know about the rule, okay? That's common sense, right? And then where most arbitrations get reversed, most discipline decisions get reversed by arbitrators, is the arbitrator finds, yeah, the employee did it, but the punishment was too harsh. You didn't have progressive discipline. It just, for whatever reason, it's too harsh. So all of those relate to the fairness of the decision. You have to convince an arbitrator that the decision is fair for all of those reasons. A note that the police reform laws changed that for your police officers, and that is no longer going to be the test. The new test is under a statute. It just has to be a cause reasonably related to the officer's ability to perform the work, but that new test isn't going to apply until there is a new collective bargaining agreement. So the statute's been in effect for almost 2 years now, but if you have not negotiated a new contract since then, the new standard doesn't apply. But we're going to be seeing a lot of arbitrary discretion cut back under this new standard for police officers. Okay, so that's substantive due process and the fairness of the decision. Now we're going to talk about procedural due process, which relates to the fairness of the discipline process. You've had your investigation, and now you're ready to impose the discipline, and that needs to be a fair process as well. Again, this is just for your just cause employees, which is mostly your folks in collective bargaining agreements. Probationary employees do not have this, by the way. Most of your collective bargaining agreements say that the just cause provisions don't apply to probationary employees. So you're kind of out of luck as far as these protections. When you are ready to impose your discipline, if you're dealing with a just cause employee, you have to give the employee notice of the charges. You have to let them know what level of discipline is being considered. We're contemplating either suspension or termination for this conduct, so that they know what they're up against. And then they have to have a fair opportunity to prepare for a meeting with the decision maker and plead their case. So you give them a written notice of the charges, you tell them what discipline you're contemplating, you give them all of the investigation materials that the decision maker is going to be relying on, and you give them enough time to prepare to present their defense to the decision maker, okay? So that has to happen for those just cause employees. A little bit different process here, and this applies to all employees that might be entitled to a name clearing. And so probationary employees, management employees, if you're going to be terminating the employee, and it's for some kind of stigmatizing conduct. So that might be criminal charges, it might be something immoral, sexual misconduct maybe, dishonesty, a finding of the person is not mentally fit to do their job. Anything that's going to create a stigma that will follow them in their career in getting another job in their chosen career. And for example, with police officers, that's pretty broad, what might be stigmatizing for them. The list of things that might keep a police officer from getting another job as a police officer is pretty broad. So they're going to be terminating an employee for that kind of stigmatizing conduct. Now here's the interesting thing. You don't have to give the name clearing hearing prior to the termination.
Say that again?
You don't have to give a name clearing hearing before the termination. It doesn't go to the fairness of the decision. The name clearing hearing isn't going to affect whether you can engage in the termination, because it's not a just cause employee. But it has to happen before you publicize the reason for the termination. And publicizing might be a press release. It might be discussing it in a public meeting. It might be sending the information to the employment department if the employee is going to apply for unemployment benefits. So anything that's going to take that information out of the employer's realm, right, and make it available to other folks. Before you do that, you need to offer this name clearing hearing if you're terminating for that kind of conduct. Now, we think it makes sense just to go ahead and give it, and especially if you have a just cause employee, their pre-disciplinary meeting will be their name clearing also. It satisfies both, right?
So explain why you would do that, and let's use our neighbors across the river again, because of all the things we know about happen in their police department. So I know some of them were terminated, some of them resigned, but there was still some other stuff. So how would a name clearing, I mean, it was clear to everybody in the investigation that those folks did what they did. And, you know, if I was an employer, I wouldn't want to rehire one of those folks.
Well, you don't have to rehire.
No, I mean, if I was a different employer, I wouldn't want to hire one of those people. So how would the name clearing?
But that's why you're giving them the opportunity to say whatever they want to say in their defense before you publish the information.
So what would be the purpose of clearing their name if they were guilty of what they did?
It's the law. You have to give them that opportunity to defend themselves in the public eye.
I see.
Now, the name clearing can be just in a private conference room. You have to offer up a public meeting, which is one reason why you folks should know about that, because it would probably happen in a council meeting where the employee gets the opportunity to present their case at a commission meeting. It can happen in a private conference room in front of the decision maker, in front of Tony if he's the decision maker. That's their choice. Or they can decide to do it in writing. If they decide to do it in writing and you're going to publish the information, you would normally want to include whatever they said in their defense when you publish that, so that when it becomes public, they're getting to tell their side of the story.
So I still don't understand what the name clearing court,
It doesn't necessarily clear the name, it just gives them that opportunity.
Okay, well, that's kind of what I was thinking. How does it do that?
It's constitutionally required.
Okay,
That's up to
okay.
them and usually their attorney. I've only one time had an employee who was being fired ask for the name clearing to happen in a council meeting. And I think she was really sorry that she did it afterward, because she was accused of, she was a city clerk, and she was accused of dishonesty, and then everybody knew about it. But that was her choice.
That happened in Westland.
She thought she was going to get to clear her name, and it's really rare for them to ask to do it in a public
setting.
Right, and that's the liberty interest. You can't deprive life and liberty. So your reputation interest is a liberty interest under the Fifth Amendment of the Constitution, and you have to provide that before you publicize. Okay. And the main case on that was City of Roseburg, and it resulted in, before attorney fees, $750,000.
Because they didn't do it?
Because they didn't do it.
Didn't do it.
And the employee asked for it. It was a police sergeant, and he asked for it. And the attorney for the city said, you don't have to do that. And it's an attorney, you folks.
So in a public name clearing event, the person who wants to make their statement in their own defense, maybe they get up and say, this is just a witch hunt for political purposes.
They can say anything they want.
There's no response to that, but it's just a statement and then they sit down. There's no other subsequent exchanges.
Right.
Okay.
Employer doesn't have to say anything, do anything, they've had their say.
Yeah, truthful or not, they can say whatever they want
You
to say.
can, the employer can ask questions, but it's voluntary, you know, it's the employee's show to say whatever they want to say.
Patrick, have you ever been involved in one of those?
I have not, no.
Well, good thing, huh?
Well,
She's
because,
definitely involved before we even get anywhere near that one.
because for union employees, it's part of their pre-discipline.
Discipline,
So, you know, they're usually disciplining a union employee, and their name clearing is happening before they're terminated as part of their, and it's only for one of those reasons, if you're firing from one of those stigmatizing reasons. Okay, so, last section here, public records, I'm sure you have general awareness, there are lots of exemptions from having to turn public records over if somebody makes a public record request. Specific to employees, there's one for employee discipline actions, that you don't have to turn over employee discipline actions and the underlying materials for that. And then there's one for employee personal information, like what would be kept in a personnel file. But for all of these, there are 2 different statutes, and there's 30 different exemptions under each statute. And for almost all of them, the exemption can be overridden if there is a public interest. And the employer is a little bit at their peril to say, oh, we think there's a public interest, so we're going to go ahead and release it. If it's borderline at all, you're probably going to be advised to cite the exemption, and then the person who's making the request can go to the district attorney, or sometimes it's the attorney general, and challenge that decision. And then if the district attorney or the attorney general says you have to turn it over, then the city is free of liability for that, right? If you decide to fight it past that point, that can get expensive because then it goes, to court. There is an Oregon Attorney General Manual. If you're not familiar with it, it's a great document. It's available online. The most recent version, I think, was the 2019. And it has 2 sections. One is on public meetings and the other is on public records. And it's searchable online. You can look stuff up. And it goes over every single exemption and gives you some explanation of what satisfies the exemption and what doesn't. So it's a great resource. Public interest, there's no bright line rule about what that means. Some examples are, if there's, it can be personal information, but if it's a public official that relates to their integrity or their job duties, then that's probably going to be a public interest. And seminal example of that was a police captain who off-duty had used an escort service that was actually more than an escort service. So that was found to, even though that was off-duty personal information, there was a public interest in that, and the employer had to turn that over. Not every management employee, but a high enough up level management employee's performance evaluation is going to go to their performance of duties, and there will be a public interest in that kind of thing. So again, there's lots of explanation in the Oregon Attorney General Manual if there's a particular situation that you are curious about. So law enforcement officers, there are some things that particularly apply to them. We just said there's an exemption for disciplinary actions, things that result in discipline. And by the way, if the employee is still being investigated and you don't know if it's going to result in discipline, you want to not turn it over because it could, right? Well, for public safety officers and police officers, if an investigation does not result in disciplinary action, then that is also protected from disclosure under a separate statute. There are several exceptions to that. Again, public interest, but also the one that I find interesting is the one on the bottom. If the employer finds that not disclosing it would adversely affect the confidence of the public and the public employer. You're always, taking a little bit of a risk to decide that that's a basis for turning something over. You're going to get legal advice on that if and when it comes up. Just need to be aware that there is this special exemption for law enforcement officers. This is a really important one. So with whistleblowers, during an investigation, the employer cannot identify who a whistleblower is. You can ask the accused person, did you do this to Ms. Jones? But you can't say, Ms. Jones filed a complaint that you did this, okay? So that's something that investigators have to navigate closely, but that's an important thing for you folks to know. And whistleblower, again, is very broad under public sector. This is specifically under the public employer whistleblower law that the identity of the whistleblower cannot be disclosed. And so that's going to be a reason why even you folks may not, be able to know about that sometimes, because Human Resources has to keep that information very private. This is not something you need to know in any detail. The Fair Credit Reporting Act does not just apply to fair credit reporting. It applies to investigations of employees for misconduct, but Congress made an exception. This is if you hire an outside investigator to investigate misconduct by an employee. In the past, that would have been covered in the Fair Credit Reporting Act, and the employer would have had to get consent from the employee to investigate them, which was ridiculous. So Congress made an exception that if you're investigating misconduct against an employee, you don't have to get their consent in order to investigate them, but the employer is very restricted in who that investigation report can go to afterward. So you might hear from us, we can't disclose that investigation report because it's got stuff in it that's protected by this law, and we're not allowed to disclose that investigation report.
And that's under the title Fair Credit. Is that financial investigations only?
No, it's any misconduct.
Okay.
The Fair Credit Reporting Act kicks in if you're hiring an outside investigator to do the investigation, and people are going to be asked, in this case it would be coworkers probably, are going to be asked about the person's character, reputation, that kind of thing. And that stuff comes up very commonly in misconduct investigations. So we always have to think about, when we're deciding what to do with an investigation report, what are our restrictions under that Fair Credit Reporting Act as far as who can see that. Okay, and then employee medical information, obviously that needs to be kept confidential. Most people think that falls under HIPAA. It really isn't. HIPAA only covers information that an employer has in connection with their health insurance plan. So if you have information about an employee because they've asked for a medical accommodation, that's protected by the Americans with Disabilities Act. It's a serious violation to disclose medical information about an employee without their consent. And even if the employee is telling coworkers about it in the workplace, the employer still has to follow those confidentiality obligations. It can only be disclosed on a need-to-know basis. The employer has to, decide what's a need-to-know basis. Okay, and then here's kind of the flip side of confidentiality, where folks assume something is confidential when it's not. So you're familiar with attorney-client privileged information, right? And that is information that you are allowed to keep secret, but that relates to information that you share with an attorney.
What?
Yes. So, you know, that's sometimes why we have executive sessions, so you can get attorney-client privileged advice that the plaintiff in a lawsuit isn't allowed to find out about. Conversations that people have, managers very frequently make this mistake, thinking that they can vent and have conversations with other managers. You folks as commissioners, there's no such thing as confidential when it comes to public records, lawsuits, having to testify about things, having to turn over text messages and emails. So this is just a reminder, there's no such thing as off-the-record conversations. Just to keep that in mind, I think I'm preaching to the choir here, but you'd be surprised how many managers don't realize that, that they can't have conversations with other managers.
About an employee?
Yes, and then loose lips sink ships. One thing that you need to be careful about when employees have these due process rights, where you can't make a discipline decision. We're talking about suspensions, demotions, or terminations, things that have a monetary impact. You cannot make your mind up about what the discipline is going to be before they've had that pre-discipline process. So even you on the commission have to be careful about saying anything that might sound like that discipline decision's already been made before that process has happened. Okay, and venting comments, stray comments, can often be what causes an employer to have to settle a case for big bucks if a lawsuit happens. That is the end of my presentation. I know that was a lot of information, and you'll probably have some questions that come up later, and you're free to reach out to me and get a copy, an easier to read copy of the materials.
Any questions?
What I probably have the most difficult time with is what I would call hearsay information. And somebody trying to provide me with information that I don't really want to hear about, and I basically say that I don't want to hear about it because it's really none of my business. There is some lack of understanding in the public eye, I believe, about the relationship between any elected official and where that goes to an employee or a supervisor or a manager. And I tried to explain that where the direct lines are. And obviously, I've said, you know, anybody can come talk to me about anything, and I can choose to talk to them about it, or I can choose saying, I really don't feel comfortable talking to you about it, or I don't want to talk about that. I know that
That makes you a witness.
I was very careful about, I was asked to come, when I was running for office the first time, I was asked to come and speak before the City of Oregon City's union. And I basically just answered questions. I didn't have any speech in mind or whatever, but it didn't get beyond that. Other than, you know, I think I was asked a question about whether I thought unions were a good thing or not. I mean, it was kind of a subjective question. I mean, they already knew I was a member of AFSCME, so it didn't really matter at that point in time. I said, well, you know, I'm a member of a retirees union. So I said that was the answer to my question. But I'm trying to be open but yet when it sort of crosses that line, say, I really don't think I should be talking to you about this, and here's where you should be talking about that with and whom.
Yeah, and we talked tonight about how an elected official can get in trouble by making any kind of comment that's taken the wrong way regarding union or union.
Oh, I've never said anything disparaging about it, other than, about a union or period. But, matter of fact, we were talking about the Cesar Chavez this at lunch, at dinner, so.
Well, I think where it comes up though is if something happens and we're doing an investigation and there's comments made related to someone's work ethic or work product, right, while we're still working on it, it potentially raises some issues, even though there is supposed to be a separation, right, between what the commission, employment-related issues are dealt with by the manager for the unions and the elected and the management staff. So, but we've seen that before, where accusations have been made in public before we even have a chance to investigate.
Do anything,
complete
yes,
investigation.
yeah. That's where my discomfort level comes into play. So,
I think something else that struck me in the presentation was, I fully believe you never mean to do anything disparaging, but for example, the comment that Dee brought up about you've got too much on your plate, you may well see that meaning the best of intentions and fully trying to help them out and include that by you. That's,
Now, don't say it to the union president.
Well, it's a really tricky situation.
But that comment as a standalone comment, it had to be related to part of a larger conversation.
it was.
I mean,
was
if the
aware.
guy says, well, that you didn't do well because your duties as a union steward are taken, and then he says you got too much on your plate, that's one thing. If the guy's having troubles at home or a sick child, and then the comment's made, you got too much on your plate, that's a very different comment. So I think it's had to be part of a larger statement. So I'm going to ask a specific question on slide 31. Is a written reprimand, is the life of a reprimand, is that the same as a step in the progressive disciplinary process, the written reprimand? For example, if he got a written warning, say stage 2 for some performance issue, and 5 years later he got a different written warning for a different matter, could he have asked that the first warning, the first written, be removed from his record, and now he reverts back to step 2?
Yes, so, every collective bargaining agreement is a little different. Some of them say the employee has to ask to have it removed after a certain time. Some of them say it's just stale after, 24 months. If the employee has not engaged in similar conduct during that time period, so that's the caveat, it's not a free pass. And so, the collective bargaining agreements used to say it had to be destroyed, but it's public record, you can't destroy it. So even if it says it has to be removed from the file, it'll be put someplace else, and it can be used for other purposes. It can be used for notice, that the employee was on notice of the expectation. But it just can't be used to ramp up the discipline. It can't be used for progressive discipline.
And I think the phrase "the same or similar nature" is very important in that, because it goes to some other agreements that otherwise could have been removed. Thanks.
It is an interesting concept that, let's say it's 3 years, right? So every 3.5 years you can do the same thing.
Well, you can't do the same thing because it'd be of the same or similar nature, but you could do a different violation that was on, like, say, the first time you misappropriated property, and that's you off with a warning, and the second time you were just some other violation unrelated to that, the first one could disappear.
So, you said what misappropriated property, so that would come under maybe dishonest. You make a broader umbrella, so then anything that relates to dishonesty would fall under, the same category. You don't look at the specific actual.
Yeah, and I recognize there's some events that go right to termination, fighting in the workplace, endangering someone else, those kind of things, but
Sorry, that just sounded really funny. I was thinking at the time when our manager, when I was working in another jurisdiction, in order to blow off steam, he bought all of us Nerf bats, and we could go into a room, and we could just take the Nerf bats and just...
Well, there's times in the workplace, whether it be public or private, where physical attacks actually occur.
Yes, I'm aware of that, but this was just to blow off some steam, so we had a separate, like a quiet room you could go in and not hit somebody else with the Nerf bat, but you could use the Nerf bat to blow off some steam.
It's self-fogging.
I only used it to, we'd have little Nerf bat fights. But we had employees that actually needed it. It was sort of a nice way of dealing with some tension.
We did not cover everything tonight, but we covered a lot, and you were a very patient audience, so thank you.
Break into exec session.
I think we're going to break for a break.
Sure.
So, we're going to take a break and come back at 10 till. 2023. Our next item on the agenda is discussion item and informational report on other agency practices on historic building systems development charges, SDC's assessment, and that belongs to our illustrious Public Works Director, John Lewis.
Thank you, Mayor and Commissioners. So there is a
Thank you, Dee.
I do have 12 slides, the 12 slides here to go through. If you remember, on August 16th, we had a conversation about 624 Main Street, and which is a historic building, and their desire to redevelop into something different. And out of that came an SDC calculation. There was an appeal of that. I noticed the count was 3 to 1. I don't remember who was missing, and I don't remember who voted what, but that's, out of that meeting came some interest in learning a little bit more about what other agencies do with regard to historic buildings and redevelopment of those as it pertains to SDCs. So that's what this is about.
Did you miss the fact that subsequently we've had a few more requests?
No, I didn't miss that.
Okay.
I know of one.
Yeah, on McLaughlin Boulevard.
It is a little different, but I was going to touch on that too.
Yeah, okay. I know one other that might be coming is on 7th Street.
Okay, so they're circling the wagons or something. I'm not really sure, but
They're waiting. They're all waiting with bated breath about what we do.
This does come up from time to time. Basically, there's law that guides SDCs. Our code guides, more specifically guides our SDCs, and then each of our SDCs is adopted through an ordinance, and there's usually a methodology memo that goes along with that. But really, SDCs are a one-time fee charged to do development or certain kinds of redevelopment to pay for existing and planned infrastructure to serve the development. SDCs may be used for capital improvements for water distribution, water treatment, wastewater collection, wastewater treatment, drainage, transportation, and parks. This is kind of the language, I think, or the definition that we're talking about here. So, most recent structure or use. This is the code section that tripped us up at least for the 624, and there's another section here that I've underlined that touches the McLaughlin Boulevard letter that you received as well. But so this definition of most recent structure use as it pertains to non-residential. Residential is pretty straightforward, but the non-residential structures means the most recent legally approved use conducted on the subject property after January 1, 2000. And then the second part of that, upon which there has been no non-residential development after January 1st, 2000, does not have a most recent structure or use. So a lot of this language came about when we were seeing a lot of buildings just sit vacant or actually I want to say it's the building on 7th Street that was kind of, building's been torn down for many, many years, and I think there was a desire to see that redevelop, and thinking that if you put some incentive in redevelopment sooner, they would come to the table quicker.
Which 7th Street property you talking about was torn down?
I think
Olson's?
Yeah, I remember that being of interest.
Well, we didn't anticipate having COVID in the middle of that.
Anyway, so we went out. Actually, the City Commission directed us to look at historic cities with historic districts in them. So there was 4 or 5 named. We looked at all of those as well as some others. So we looked at a total of 15 cities. None of the cities were viewed to treat their downtowns any differently, and none of the cities we reviewed treat historically designated property differently. The one exception to that, and I think it's a different scenario, but some of you may be familiar with the fact that Corvallis used to be Marysville. This is something I learned from, by the way, Josh Wheeler did most of the research on this, and so he helped put this together, but so he shared with me a Marysville and Corvallis, they treat that area, that Marysville area, which was Corvallis before Corvallis got named Corvallis. So Corvallis got named in 1853 to avoid the confusion of the name Marysville, California. So that's why they changed the name. But anyway, they do an SDC reduction or exemption for that Marysville area. So anything that redevelops in that area is exempt. Okay. So that's the only.
So you're saying exempt or they get a reduction?
No, exempt from SDC, so they don't pay an SDC in that area. The thing that I keep tripping up is the nexus to get there. I haven't figured out, or Josh hasn't figured out the nexus to why that particular area, but I think they've just kind of they've provided, that's I think a policy decision that can be made to say this particular area we're going to identify and not charge an SDC there. It's much more, it becomes kind of a slippery slope when you start making decisions about exemptions or reductions in SDC without what I consider a nexus. In Oregon City, we have an area, we call it the mixed use downtown area. It goes up the 7th Street corridor. We have basically an SDC reduction that we've adopted through an ordinance for transportation SDCs in that area, right? So development can go from a low use to a high use if you're in the mixed use downtown, and because of the code that we adopted for that mixed use downtown, they would get basically they would get credit for whatever they wouldn't have to pay an extra for that increased use, mostly because the mixed use downtown corridor in theory is supposed to provide more transit related, more walking to work related kind of thing. So that's how that nexus happened. But in most cases, there isn't a good nexus for this. So, so anyway, that's kind of what we found. I'm going to go through that in a little more detail as well. So I don't want you to get too hung up on that particular Marysville scenario because I think it's unique, and I'm not sure they have a good nexus for it. Several cities do create SDC exemptions, and the first one here I've got listed as this low income and elderly persons. We found that in their SDC or fee elements. I think that's got more to do with tax deferments, utility payments, but because SDCs fall in that same area, it applied to them as well. City-funded projects, there's some cities that exempt city-funded projects, like this building, for instance. We don't have that exemption, but some do. Florence exempts ADUs from SDCs, and I think that's got to do with some of the housing needs. And some cities exempt affordable housing as well. The other thing we looked at is look-backs, or that year provision that we have in our code that says anything that's prior to 2000 doesn't necessarily count in our look-back. So there's a few cities that have look-backs. Some go back to these other years, 72, 77, 1991, 1994, and then we've got 2000. I think one other city has the year 2000 listed as well. Ashland also implemented a discount, not an exemption, but a discount for affordable housing. These are the cities we looked at. There was 15 of them. I think the ones you asked for, if I remember correctly, were Ashland, Jacksonville, I think I may have this, Astoria, and Albany. Those were the cities that we heard on the tape.
That's because I know those cities have major historic districts. And that's part of, what makes those cities fairly unique. Baker City in particular, Jacksonville, the whole town pretty much is a historic district, all on the National Register. But they don't have a lot of new construction, but they do have, what I would consider to be major adaptive reuse, where they take, a building that was built during the gold rush times and they've converted it into something else.
And the only other thing that I wanted to add here was Astoria is working on adopting an SDC ordinance that would be for all the utilities and the transportation system. Right now, they don't have an SDC.
Yeah, I called my
so-
buddy over there, that's what I found out.
Yeah, and then Joseph was another city that has kind of a unique downtown, so we looked at that, and they don't really have SDCs, but they do have some connection fees, but they're on a much smaller scale than anything that we would have over here. And I would also say that generally, when we participated in the League of Oregon Cities SDC study, we learned that SDCs are prominent in the metro areas. So cities with no look-back date were Albany, Ashland, Astoria. Of course, Astoria doesn't have the code yet, but Brownsville, Cottage Grove, Cannon Beach, Florence, McMinnville, and Oakland, and Sisters. And so, because they don't have a look-back date, that means that they recognize any kind of history that that building may have had. So, for instance, in 624, there's some documentation that the owner provided that indicated that there may be a restaurant, been a restaurant in that building at one point in time. So, you know, looking back at historic records, I guess, looking back at information that the applicant brings to the table would be, you know, in our case, we would only go back as far as 2000, but in those cases, there is no look-back date. Cities that do, the other cities that have look-back dates are listed up there: Bandon, Corvallis, and Jacksonville, and then Oregon City's got the 2000, year 2000 look-back for non-residential.
So I don't want to disparage Sisters, but most of Sisters is not historic anymore. It's kind of like downtown West Lynn, where it's been recreated as a themed town.
Yeah, like Willamette.
Yeah.
You know, in our effort, we just kind of wanted to give you as much information
I
as
know.
you could. I'm not trying to say
No.
they're all historic. I'm just saying
I know you aren't.
that we were trying to do a pretty extensive look at cities kind of our size, and we've done some of this with the commission before where they wanted to see comparables, and so while we didn't hit that list completely, I think I didn't have a slide, but in the staff report we did some just code research in our review. We did some call outs and had conversations with folks on the phone for others, and then we also checked in with the FCS group, who had a 2010 study that was pretty similar to this that they shared with us as well, so we looked at that information. Again, just going through these, Astoria, any structure established to honor before the adoption of the SDC ordinance would get an exemption. A lot of these do that, with the exception of water and wastewater, which is kind of an interesting exception. They give them SDC exemptions for transportation and maybe parks, but not water and wastewater. And that's true for many of these on here. I'm trying to think if there was anything else. That Corvallis one is listed. Sisters is not a date specific, but any structure established to honor before the adoption of their SDC ordinance. So SDC discounts and exemptions, I still can't figure out the elderly and low income as it pertains to SDCs. I think that's more about fees and, you know, low income breaks for a low income discount for, you know, elderly. I, you know, anticipate elderly and low income people coming to bringing a project to the table that's got SDCs associated with it.
I don't really see that. That's not relevant to me.
Yeah.
I don't know how they do that.
Affordable housing, there are some cities that are using SDCs they've found a way to get to that for exemptions for a couple of locations, Cannon Beach and McMinnville. Again, we haven't dug so deep that we found what they use for a nexus for that, but there are a couple of those. Again, yeah, just city project exemptions. I wouldn't advocate for that, especially after I just built a building and paid a chunk of change for SDCs, but
No, we probably should exempt ourselves. I mean,
but we do have that mixed-use transportation discount, so, I think that, and that's turned out, that is actually pretty helpful for a lot of our downtown businesses. So, I guess, we re-listened to the conversation that we had on, with, like I said, there was only 4 of you there. But, just trying to figure out, this is a policy decision. I'm still not exactly sure what, I think people would like to see redevelopment of some of our historic downtown. Is that what we're trying to target? And is it just in a downtown area, or is it all, we've got a lot of historic buildings around the city, right? So are we targeting those? If we could get a better understanding of what you were thinking there, if it's any kind of housing types, are we trying to promote affordable housing or middle housing? Because we've got some provision for that, but we're noticing other jurisdictions are tiering some of their SDC rates. So I think by the way, I think the affordable housing, if you can justify less trips, for instance, but it's a little harder to justify less water use in some of those. So it is, to me, kind of trying to bring back to the commission a little better information about where there might be a nexus. We'd probably do a better job of reaching out to FCS Group on trying to establish what's a potential nexus. If we're looking at historically designated buildings, we really didn't find much out there that justified any kind of a discount or an exemption for those. But, I think the problem would be if the commission made a decision that they wanted to kind of exclude historic buildings, for instance, then who's the next to ask? And, how would the commission kind of defend its decision to give that exemption or give that discount? That's the thing that I'm a little bit worried about, and I think because we've talked a fair amount about this with FCS Group in the room, and they've provided really pretty good advice about that. But again, I think it's not illegal. I think it's just kind of that, is that something we want to step out onto?
So can I flip the paradigm? I would like to approach this from the standpoint of what we can do. I think that, I don't have nothing against FCS Group, but I think given the policies we have in our comp plan and some goals and policies that we are trying to implement, I think our consultants were remiss in not looking at this from the get-go, because knowing the history of this town, let's face it, we don't have buildings downtown that date from 1844, but we definitely have some buildings downtown that date from the 1900s. And I think that if we are talking about trying to create a vibrant and prosperous downtown, which I'm not reciting the goals specifically, but we have goals in our comp plan, we have goals in our codes that talk about the redevelopment of the properties. And I'm not asking for people to get a wholesale exemption. I think the housing discussion is a separate thing that I would like to keep. It's a similar parallel, but I think we need to talk more about the type of housing that we want to see, maybe talking about a reduction. I'm not talking about an exemption. I think middle housing is where we need to go, because that's what we keep hearing about, and nobody wants to build it. They only want to build market rate. And I just had my interview yesterday, Tony, with the folks on my statements, and I was really clear on that we are not getting the production we need because, number one, we don't have the infrastructure, and number two, there's no incentive for the home builders, and I was very specific, to build this type of housing because it's all profit driven. So where I'm coming from for your nexus with these historic buildings, number one, I think we have to be, it's not everything in the mixed use downtown. I think there's got to be a couple of criteria. Number one, it's got to be, I would say it has to be on the city's inventory to qualify. It's got to be on our list. We've already shown that those buildings are designated. Now, we don't have a lot of things designated downtown. We've got one building on the National Register. We've got potentially eligible buildings, and we've got a whole list of them that are like, they've been so altered, there's nothing left. So I'm thinking of a building like the courthouse, which is eligible for the National Register, and that would be you know, a goal that I would have to say, we need to work to get that on there. So it has to either be designated as a resource, which we've already got documentation, or there's documentation that can be backed up with facts that the owner provides, not the city, to show that that building has got some, you know, historic. So if we want to just throw out, you know, let's throw out the Weinhardt building, for instance, because they're not asking for anything. So we know that that building was built by Henry Weinhardt. It is associated with events. It has one of the first breweries, not his brewery, but he outlet somebody else. So there's a whole history about that building. So let's say they want to come in and redevelop the upstairs, which could make some great housing units. I would want to see us in some way help them get there, because that's going to be a heavy lift. It's going to need seismic, it's going to need all sorts of things. So the least of their worries should be they're going to get hit with a big old SDC charge. We know that that building is eligible to be designated. It's documented. We know that it's historic. It just hasn't gotten there because, let's just say we had a little kerfuffle with Tom Bush Sr. So there needs to be a criteria. So for instance, I would not say that the Lithia Subaru building would qualify for this, even though it's in the mixed use. There's nothing historic about that whatsoever. So those are two things I think we can hang our hat on, and somehow, in order to promote economic development, vitality, a strong downtown, which is our living room, I really think we need to very seriously look at how we do this, because not everybody's going to be doing this on their own with their own dime, like the owner at 624, but there may be others. I know I've talked to a number of those owners down there, and they would like to do something, and they're all hanging back to see what happens with this building. And I'm not saying that nobody will do anything, but we had the old JCPenney's building redeveloped, and that developer did that on their own, and now there's ZCS and the liquor store and wherever else is in there. We've had one other building, the McCall building got redeveloped. That was done by an individual owner, but they kept the uses that were already there. But the upstairs, again, has the potential for residential occupancy. That's what it was originally. They lived upstairs, they had their store downstairs. The Petzold building's on the National Register. It's been turned over to the guy's granddaughter, Herb's granddaughter. And, you know, she's not a developer, but she could possibly partner with somebody, and we did a little study on their building when we had the Downtown Association did these little mini studies on reuse of buildings downtown. So that's the nexus that I want us to get to take a look at it, because we're not really walking our talk in terms of doing that. And if we don't find a way to help facilitate, I mean, like I said, you know, I want Larry to redevelop that building before I'm serious, before I die, because I talked to him about it in 1988. Kathy talked to him about it before that. It's not just the Larry Medeiros of the world, it's the other buildings that have the potential for us to get there. And again, as the first city, I think we can do this. I really think we can, without causing a lot of disruption. And again, I think the two criteria that I've given you for the nexus, making the owner, if it's not designated on our inventory, making them do the research. I don't want you guys to do the research, but that research can be collaborated. And then the other one is, like I said, on the inventory, we already got the information. So how can we get there to help facilitate economic development and still meet the goals of what we want to try to do in terms of collecting SDCs, but yet take that economic development component and really help boost that?
I guess I'm uncomfortable setting up, because I can come in with history of a building, who's going to determine whether it's significant or not?
We have experts in this town. If we need to have,
it's not very clear. It's going to be an argument.
I'm just getting to the broad
But
topic.
I guess the second thing is, knowing where we're at, trying to deal with our infrastructure, are we going to backfill the SDC, or are we just writing it off? I mean, it seems like if it's truly an economic development or historic preservation initiative, we used to do storefront grants through urban renewal, right? Which, I don't remember if SDCs were one of the things eligible. It was so long ago. But for a developer who's got a pot of money, they don't really care, right? I'll use use it. If it has to be for the exterior improvement, then great, I can use that money. I would have had that and put it to the SDC.
McCall
right?
building got something, I can't remember exactly what he
It
got.
seems like the better way to do this would be to set up some type of a grant program that a developer can apply for that meets, whether it's a, kind of similar, it's a historic building or a storefront that can then be voted on, because then at least, we're not shortchanging the SDCs that we've identified that we need for our system over the long haul.
Oh, I'm not talking about shortchanging, I'm just suggesting that we look at a reduction for those. I mean, looking at what...
If we don't collect, it's shortchanging. I mean, we won't collect it anywhere else.
Well, again, that's a decision. I mean, I'm looking at amortizing that cost across the board once that building is rehabilitated and we get increased taxes from it because it's not looking dilapidated. So there's got to be, a balance somewhere. I understand that we don't collect it here, but is there a way, to maximize our return on the investment and help these buildings not sit there half unoccupied, because nobody can afford to do this. I mean, if I saw that SDC charge, I think, make my hair fall out. I mean, that's a big lift. And I know that we did some things, really good things downtown with the storefront improvements, we did some tenant improvements, we did that, but we weren't talking about changing a use from one thing to something else that was more intense. That's where I'm trying to figure out how can we support that and still achieve partially what we need to deal with these SDCs, because it doesn't help us to have these half-vacant buildings downtown, and that is exactly what's going to continue to happen if we don't figure out a way to try to, and again, downtown to me is different than the hilltop or any place else. I'm sorry, it's a different category. That's why I was not saying the entire mixed-use zone, because not everything down there is historic. I mean, once you get past 10th, you're kind of getting into, that's new construction, it's been remodeled to the point to where, there's not much historic integrity left to what's there. It's basically it's from 10th over, and it's not all the buildings. Not all of them are meeting that standard. I mean, obviously the law library building where the juries meet, that it's long gone. But I can think of half a dozen to 8 buildings down there that could do this, that are underdeveloped. And so again, we have conflicting goals. Are we collecting SDCs here, or are we going to have, continue to have, vacant buildings or underutilized buildings? And it's a policy decision. That's what I'm saying. If there is a way that you just came up with an idea, if there's a way that we can, as staff and commission, think about what we can do to help facilitate this redevelopment. That's really the bottom line of what I'm looking for. What can we do to help facilitate this? It may not be the SDC reduction, but that was what was in our face right now. So that's all I've come up with is, and I understand what John's saying about the nexus. We've got to be able to justify it. That's why I said we've already got a historic inventory we've adopted. We can point to these buildings, like the one at 7th and John Quincy. We know it's designated. We know that it's had, it started out its life as a store and a residential occupancy upstairs. I don't know what they want to do with it, because they're waiting to find out what might be out there in the market, and then what somebody comes to them and says, oh, I want to put a restaurant in. Well, I'd be thinking twice about that, because that's probably the highest SDC charges. So that's all I'm asking is,
right, so
let's look at it from a positive standpoint instead of, well, this is going to do this and this and this. How do we achieve the overall goals that we have that may seem to be conflicting, but really aren't?
Right. I consciously made a decision not to bring the whole how much we need the SDC part of the conversation. It's a huge need. I think you guys get that from other conversations that you've had. It is a huge need. You're thinking about collecting less. It's like, okay, what does that mean on the other side? But if it's about, other agencies agency, we didn't go into looking at grants, for instance, and what other agencies are doing to help support kind of the development costs of a redevelopment of key properties, right? But we can kind of dig into that.
But we don't control those. I'm talking about stuff we can control.
Well, that's a city-provided grant is what
Okay,
we're talking about.
all right.
Yeah,
You
city-provided
said
grant.
grants, I didn't know if you were talking about others.
But I wanted to go back, because you said you had two criteria, and maybe I just boiled those down too much, but is it a designated resource? That's kind of one criteria.
That's one we have.
What was the other one?
We have a historic inventory said that they can prove that the building is older than, that dates from the 1900s or whatever, that we know that we have documented use going back to.
Documented use of a historic building is important to you. That's one.
Right.
What's
This is
two?
That's the second one. If it's not on the city's inventory,
A designated landmark.
so there's
So
the
it's not-
designated landmark and there's the non-designated landmark.
Okay.
That's why I said in downtown, nothing is really designated except for a couple of buildings. So they can demonstrate that this building
Okay.
has some history going back, and they can document it by going, let's say they go to the reverse directories of the library and they show, had Joe's Barber Shop and this shop and that shop, and then, because that's all in there. You could, I've done research on that myself, but that would be their responsibility to show documented research published that this building is got these uses in it, because we have inventories for all the buildings downtown. Even the ones that are not designated. We have that, but they're just not designated. And there's a whole list of, these are eligible, these might come back, and then they're gone. They can't be restored because they are too far gone. We already have all of that information. They would need to take that information, that the buildings that are eligible, and say, I can document that this building dates from 1905 and this was what was in it. That way you've got something to base the fact that there were prior uses in it that may be different than whatever it is they're proposing.
And I'm also hearing it's a pretty small area, maybe 8 or 10 buildings.
It could be more than that. I have the inventory at home. I mean, I could go back and document that and say, I think it's this many buildings. But again, to me, it's different than if, let's say that Danielson's Thriftway came in and says, I don't want to have Safeway anymore, I'm going to turn it into an Al's gaming, bowling, whatever. That's a whole different ball of wax than, the McCall building or the Petzold building or the courthouse. Sorry, Craig, if you're listening out there. It's just something I thought of, because I know somebody took an old grocery store and turned it into that kind of like kingpin thing where you have gaming and videos and bowling and a restaurant. I mean, it's pretty amazing. So I don't know, does this historic part thing make sense to you, that what I'm talking about in terms of really honing it down so you've got something to hang your hat on? It's not that I'm making it up, we got an inventory.
One of the things that would have helped in the 624 was this look-back provision. We've set that at 2,000. A lot of agents, so that's a fairly easy change. It would be citywide. It would be a citywide change. So it doesn't target those 8 or 10 buildings or whatever that number looks like. But right now, we've set that at a date certain. Many agencies haven't. So there's that.
See, a lot of cities aren't as old as we are. That's where I have a problem with for the older buildings. At 2,000, that's a drop in the bucket compared to the age of stuff we have here in town.
So I'm hearing you'd like to see either an earlier year, or you'd like to see it go away.
I know it sounds arbitrary, so I'm just going to throw it out. So let's say we say that if your building is documented was built before a certain date, you can get that as your look back. If it isn't, then you go with that one. I mean, it's a two-tiered system. Again, there's stuff here in town that, why would we look back beyond 2000? Because we know it's
But I think that's
relatively
gonna be
construction.
too arbitrary, and
Okay,
we're
well,
gonna have a lot of,
I'm just talking out loud.
Yeah.
You're asking me questions and I'm trying to, in my head, justify how to do that look back.
okay. The McLaughlin property where, we've got, you all got a letter on the McLaughlin, the property in Kenema.
Yes.
It's a house. We found, little to no information on the fact that it was legally, so the way that definition reads, if you remember in the section that I had highlighted in red with underlined section, most recent legally approved use, to us that means is that we have evidence of a permit.
Exactly.
In that case, we don't have evidence of a, quote, permit that it was ever permitted to go to, an office building. So we don't have it in our records. They could produce something, I suppose, so.
It was an antique store when I left the city.
Yeah, so I think there's plenty of people that would say, we see it in our inventories. It's more about what's the threshold of legal use. Because, again, we could make a more liberal decision about whether or not legal use is, it's on our inventories, our historic inventories. Does that mean that it's a legal use? That's their point, right? So, we're looking at permits and, that language could change to most intensive, legally permitted use.
When it was placed on the inventory, it was a residential occupancy. I just reviewed some files from back when we created the district that I have from prior staff. It was residential. It was never an office building. I mean, I don't know when it became an office building, but, I'm specific, maybe getting in too far into the weeds, but yeah, I mean, I think you have to have some threshold of a legal use, and just because it zones something, that doesn't mean you can just move in and start doing something else there.
Okay.
It's a misperception that people have, period.
Anyone else?
I think they're tired.
I get that people are tired. We're also trying to provide information, but as the folks who administer this, having these gray areas make it very, very difficult, and then everything comes before the city commission, right? That's where having clear lines, as clear as we can, have been helpful. It just means that there's gonna be those cases where somebody's gonna come before the commission.
So what did FCS say about the fact that, maybe you didn't ask it this way, but if they were sitting here today, I would say to them, okay, what can you help us do, given the fact that we're the oldest city in the state, we've got really old buildings, and the SDCs could be a deterrent to redevelopment, and part of our goal is looking at how we're going to get, the best return on investment that we can, and what can we do, you guys are the brainchilds of all of this stuff, you guys are the brain trust, what can we do to make this more palatable for somebody to think about possibly redeveloping without it crushing them? Given the fact that we've got infrastructure issues. Now, I don't know what our infrastructure issues are downtown. I haven't discussed it with you for a long time.
Well,
but
what I've heard from FCS Group in the past is this idea of the city using something like urban renewal to pay those funds down. Lake Oswego's done a lot of that kind of work.
If we had the ability to open our wallet and do it, that's exactly what it's for.
I think you're right.
That's exactly what we did.
That's how cities are doing it.
Exactly how we did at Portland Development Commission. That's how we got all of those historic buildings redeveloped. That's what we used the money for. And why we can't get our community to understand that it's an investment in our future is frustrating to me to no end.
Well, the historians have spoken and they all sit over there. And I thought the basic methodology of SDCs was good. everybody at this table, whether we sit on this commission or other boards where we probably need to update our SDCs elsewhere to reflect the changing costs of what we're encountering in facilities construction. I view the matter as an economic development matter. And there is that, city manager talking about how do you refill that if you simply waive it. I don't think we waive it. We may make some consideration, but I'd like to see it treated, maybe it comes out of the economic development fund, or maybe we can get to an urban renewal point. But in the end, it's an economic development matter. And I'd like to treat it as such. I'm all for preserving history. I do want to put a limit on the look back. I don't want somebody coming in here and saying 1868 there was a restaurant there. And we know that because we found an old spittoon in there. And you know.
We need more than that.
Well, yeah, I know, but I mean, you know, you're going to have applicants' account, which is going to be, you know, you're going to look for those things that favor your position. I think there has to be some limitation in terms of years on the look back.
Documentation, that they need to show documented proof, a secondary source that says this is what it was.
Okay, but if he says there was a restaurant in 1868 or it was a bar, which means I'm not changing the use now in 2023, that just doesn't fly with me because it's such a very different animal. So, I mean, I think there has to be a limitation on the years of look back, but again, not to be repetitive, I view it as an economic development piece. And I'd be more in terms of grants or subsidies. And then, you know, the other piece is when we did the storefront things, you know, I kept thinking about what about those people you give a huge amount of money, they develop the property and turn around and sell it and reap the profit. I don't want to get into that discussion tonight, but I mean, there has to be some commitment that we're going to help you, and in turn, you're going to help the community.
The storefront grant, I thought we had, Tony, didn't we make it 5 years that they had to continue to maintain, or there was a payback of the money?
I don't think we did. I think there was.
I don't think we did that back then when we were doing storefront grants.
I wanted to, but I don't think it flew.
I know we did that at PEC, and we made it 10 years.
We did some things for the economic development grants, just micro grants that we did.
Yeah.
There was a payback there.
Penalty
But
for early withdrawal.
I don't think for urban renewal we did storefronts. There was a time clawback.
No, they're just outright grants. And you gave it and it was yours, and if you could benefit from it financially, you had that option. And I never agreed with that.
We made them sign, if you get this money, this is what your obligation is.
And I didn't mind if that obligation decreased over a certain period of time, like 5 years, 20% a year or something. But again, I don't want to forego SDCs because we all sit on the other board and we see the position we're in where we can't even, the affordability of new structures and service structures is doubled.
Well, we told the staff from Merkley and Wyden's office that one of our biggest needs is infrastructure. And I told the same thing to a governor's staff person. It's infrastructure. We can't do this without this.
That's right.
And I agree with you. It is an economic development issue.
It is, and I mean, I'm all for economic development and conversion of historical structures into usable things, but I don't, maybe you make some sort of allowance, but by and large, you collect the SDCs and you offset them with a contribution from another fund, whatever that fund may be.
Is that an option for you to look at? An option for us to look at?
Certainly, it's a budgeting decision. I mean, it'd be general fund.
Well, some of those are specific budgetary allocations to departments like economic development.
Sure, but out of the general fund.
Right.
Right, where we allocate to police, parks, ECDEV.
Sure.
For those programs, right, like we did for, like community events, right? We set aside money specifically for that grant program to be set up.
But where we invest today by helping get this or other projects downtown off the ground, we will reap the benefit. You know?
No argument there. The question is how do you do it and maintain your income streams as you need them and pay out of the proper accounts that reflect what it is you're trying to do.
Because I mean, that part of my, as I keep telling Larry every time I have meetings with him, I said, you have the 100% corner. In my opinion, you have an obligation to do this because, you know, this building has been dragging out of down. I was very blunt with him. I said, this building is dragging part of downtown down by having that the way it is. And there's a couple of other right next to them that need some help.
So I agree with the premise that you're bringing forward. I just disagree with the way that we can accomplish it. I think we need to have something that is objective. I don't want us to be putting in a system where any one developer can come appeal to us and make their case on facts that they can dig out of nowhere. I don't want to put us in that situation, and that's why I wanted us to have this work session rather than confirming or affirming that SDC appeal. That shouldn't be what we're doing with a bunch of subjective facts. And so I also do not want to be shortchanging our SDCs and our infrastructure. So whether that's a grant program through monies that we've already allocated to economic development, I mean, just thinking about the ways that the money in that department are being allocated now, like for example, what are the returns on investment from funding a float in the Rose Parade, as opposed to if we were to allocate something instead for redevelopment in the historic areas, is something that I think we should have a conversation about. So I would prefer that we look at grants, whether it be through the city general fund or urban renewal, once we are able to have that discussion. But I do not want to be putting in place a subjective process that leaves it open to be brought to us every single time someone disagrees with staff.
I don't want to do that either. I don't want to keep hearing these appeals, which is why I'd like to see something that we can reasonably manage that's in place, because it's just only going to bring up the fact that, you know, it's a buyer beware situation. You buy a building, you think it's X. You might have not done your homework to find out it isn't X, it's Y, Z, and whatever else. And, you know, again, that I'm sympathetic, but yet I look at the caveat emptor, you know. Don't assume anything when you are buying real estate. Nothing. You cannot rely on something. And it was funny when I was doing the research on that particular building, I'm sure that that person is related to our former chief. Gordon Harris. Her name was Maya Harris, who had the antique shop. So you think about that, see how if there's a connection there, because that name's just not that common. And there were lots of two or three Harris families that were living in Kanema back in the day.
So in my mind, like a question that pops up is, does the high cost and the prohibitive cost of SDCs qualified as a but-for clause that would qualify it for an urban renewal? It would be developable but for this situation, which is a blighted area.
Exactly, I agree. And that's how we looked at it when I worked in Portland. We used some of urban renewal money to offset those types of charges. So a building, you know, I mean, we're talking older than 624 Main, could redevelop.
That's how I feel that, and then the coffers wouldn't suffer, and the SDC fund wouldn't suffer, and I mean, we know the realities of what it costs to construct infrastructure.
Could you give us a brief overview in the future? I don't really know what the infrastructure is like downtown, and I don't know whether we know as a city all of what's, I mean, do we still have really super old stuff down there on Main Street? Or because of some of the many projects we've done over the years, we've done some upgrades to the infrastructure. I mean,
We've done quite a few upgrades.
That would help me in terms of looking at what the future is of that. So, I mean, I think we already got in our plan what we think the future is of that plan, of that area, but I don't have any idea of, you know, what the infrastructure is, whereas I know pretty well from your advice and everything, I know what's going on up here. And in McLaughlin, I know about that infrastructure, but down there, because it's so built.
Well, that's why, I mean, our SDCs apply citywide.
Well, I know, but
downtown, there's some old infrastructure, but, you know, I'd have to look to see specifics, because we've done a lot of improvements downtown.
Yeah, absolutely.
So some of that SDC is reimbursement of some of that work.
Yeah, I know when we redid Main Street, you found a lot of interesting things when we did the upgrade to Main Street, including rail tracks and everything else down there.
Yeah, you're right, there's a lot of, it's just
Yeah.
improvements. Yeah,
Yeah. Okay.
yeah.
Is that all?
That's all I had. I didn't,
That's great. I appreciate it, and I'd like you to come back with some possible ideas, and that we need to do whatever we can to discourage these one-off things, because it's just not helpful.
I just want to second what was put up as an option at the end of the presentation, that even though this conversation was prompted by redevelopment of old buildings, that while we're doing this, I would like us to also be looking at how we can incentivize middle housing, as was already mentioned. I think that's something that's overdue for us.
Yeah,
I think that's probably gonna come,
later,
well,
a little bit later.
we've got the governor's task force, and they're coming out with those recommendations, and that's some of what we've seen, some of the recommendations, so I have a feeling we're gonna be having that discussion.
Yeah.
Being wrapped up in other
I'd like to get ahead
ideas that are.
And we can be proactive.
Yeah, I'd like to get ahead of her stuff, if I may be so blunt. I'd like to use another word, but we're on the public record, so I will say her stuff. I know that Frank's gonna appreciate this, but, I would like to hold, commission committee report updates to later. I don't think anything substantial has happened since last month, so.
Did you hear my heart break?
I'm sorry, Frank, I can see that there are tears in your eyes, and
Tears of joy.
I will make this up to you if I have a consensus of the commission.
Did you spend hours preparing for that?
He did,
He has a slideshow.
he's got a, Frank, could you get,
I defer to greater minds.
could you get your, USB port out so that we could plug your,
I can just send it, I can mirror it.
could you just send it? Okay, that's perfect. We'll just do airdrop and I'll get your 15 slides. So is that okay? Is there anything pressing that's under these topics that we need to tell everybody about?
I didn't see anything that really has changed.
I do want to throw one thing out for your consideration to think about later, is that, I was asked about whether or not we might consider having a peace pole down by our peace tree at the trail center. And I said, I thought that was a great idea, and I would just throw it out at the work session and we can talk about it some other time.
If I may, about tolling.
Oh, my favorite topic.
That's the only thing on my list that I think is worth bringing up.
That's what I just asked, is there anything?
So, at our C4 toll strategy subcommittee, we heard from staff about the RMPP options. That's the Regional Mobility Pricing Project. And remember that RMPP is separate from I-205 tolling. This is across the entire metro region. And so we were looking at ODOT's preliminary options for how that may be implemented. And the reason why this is important is because these were the options that were proposed, or that were presented to residents in their questionnaire about, to try and gain public input on their proposals. And so at our general C4 meeting, we discussed the potential of a partnership between the jurisdictions, potentially hiring a pollster to do our own questionnaire. And so I think
One that wasn't biased?
one that isn't biased. That was something that was just thrown out and that we'll probably have more conversations about, but it may be a good investment to give us some stronger footing when we're having conversations with legislators and other stakeholders, so that ODOT staff can't just say, look at our results, this is what people want. So that's something that we talked about. And we also did discuss managed lanes. Another term for those are express lanes. This is something that a lot of us have been advocating for as an alternative, rather than tolling all of the lanes, tolling one of them and giving people the option. If they want to go faster, then they can pay for the toll. And ODOT they responded to us about this and basically told us that why it wouldn't work. It felt like starting with a premise and then going from there about their study why it wouldn't work. But
I know they do that in California.
They did tell us that that would not be conducive to the goals that they're trying to accomplish. But we're going to still keep pushing on alternatives. And also the legislative subcommittee that was formed by the governor as part of the pause met for the first time, and I still need to go and watch that. But hopefully there will be news coming out of Salem regarding alternative options. if we have some legislators who are willing to stand up for us. So.
Well, I watched it, and I will say in summary, the thing was, is that Susan McLean got up and basically said, well, where were all of you in 2017 when we passed that? And luckily, Mr. Byer and Representative Hartman said, well, circumstances have changed, and the same people that were there in 2017 have new information that the stuff that you talked about in 2017 is no longer valid because the situation has changed in our state. So you can't just keep trying to shove this thing forward when the world as we know it is not the way it was when you passed this in 2017. It was kind of like, this was the wagging finger thing. It was like, well, you know, and then Lee Byer was one of the wagging fingers. Well, we've been working on this for years, and, so I was not impressed with the outcome of the hearing, and basically what the committee told those folks who were testifying, so to speak, was that you're not listening. So that's the sum. And we will talk about it some more with our friends in West Lynn. So, all right, we are adjourned.